am Delta Aura. I am a law lecturer in Adigrat University, and I am a practicing lawyer. And I specialized in environment and land law. And in this session, I give you a lecture on land law, and I need to say thank you for watching my video in advance. And the first session talks about the purpose of the course, meaning of land and land law, theories of property rights and land significance, and the scope of land rights, and forms of ownership of land and the scope of land law. Finally, object of land law. So these are the basic points in this session. So I will give you clarification. So when I start from the first point, what is the basic purpose of the course? So the basic purpose of the land law course is to identify what are the basic rules and regulations which governs land resource. This is the basic aim and purpose of the course. So at the end of the day, when we finalize this course, we understand what are the basic rules and regulations which regulates land resources. So we understand the fact that. So the second is meaning of land and land law. When we start from the meaning of land is just like one type of property. So just like other properties, it creates a right or a relation between the property and the persons, and it also it is a right emanates from the property by itself, just like other properties. It includes just like other properties, it gives the right to use, the right to enjoy, and the right to dispose. So land is a type of property just like other properties, one type of property, but it is very important. It includes the bundle of rights. The other is land law. Land law is a type of law just like other types of laws, and land resource was governed by other general laws, but recently land law is a specific law which is enacted recently to specifically for land resources. So land law is a specific law which regulates land resources specifically, and it is developed or enacted recently, just unlike other type of laws. So this is what does mean land law. So the other is theories of property rights. There are theories of property rights which gives how to acquire, or what are the mechanisms to acquire land rights. So just when we see the origin of the right of land, just as like other properties, land is a property and it originates based on the porteurs. So when we start from the first one, occupation theory. Occupation theory directly refers first possession or first occupants of the land resource is a ground to claim land rights. So in this theory, the first possessor or physical act or cultivating or fencing or doing any activity on the land which are not owned by other persons, or if the land is unowned before and the individual invests or physically acts some activities for the first time, so the person who possesses the firstly has a right to claim land rights. So first occupancy or first possession, physical possession of the land is a ground to acquire land rights in this theory. So applying this theory is more or less difficult when we see in the modern world. Maybe it was applicable on the customer practices. So first occupancy is difficult at this time because land ownerless lands are not accessible in this time. So this is more or less difficult, but it is basic idea is land rights emanates from first occupancy or first possession. The second one is labor theory. When we see the main concept of labor theory, investing some labor or adding labor to the resource is a ground to acquire land rights. So mixing labor gives to the land a value to handle or acquire land rights. So in labor theory, adding some investment or some labor with the land or in the land, mixing hand activities or labor is a ground to acquire land rights based on this theory. Just to unlike occupation theory, in labor theory, investing some labor or adding or mixing to labor with the land is a requirement to acquire land rights. Second is social contract theory. When we look at this theory, social contract theory gives as a requirement, law is a ground to give land rights, just unlike the first one and the second one. So in social contract theory, there is a convention or an agreement between the whole society and the government, and they enacted law to distribute land rights, and citizens can claim based on the law to the government. So the government has a duty based on the law to distribute citizens of land rights. So in social contract theory, the law is the main basic ground to give and take land resources and land rights for individuals. So the government has a duty to distribute land rights based on the law. So the law is the basic one and an agreement between citizens and the government. This is recently applicable in different countries. The fourth one is utilitarian theory. In utilitarian theory, giving maximum production to the public rather than an individual interest also gives us or uses as a requirement to claim land rights. So in utilitarian theory, the requirement is giving maximum utility for the society or maximization of production to give more benefit for the society is a measurement to give and take land rights for individuals. So in this theory, giving concern for public interest is the one rather than giving concern for individual interest. So the measurement to give land rights is whether the maximum utilization of the land resource gives to the society any benefit, whether it is fair, whether it is sustainably important, or if there is sustainable development, if there is benefit for the society, if there is maximum utilization or production for the society. This is a ground to give land rights. So this is the idea for utilitarian theory. So the other relation to this is anti-property argument. So unlike the first four types of theories, anti-property argument is an argument which argue to personal property. Giving personal rights for individuals creates or results for social instability or moral instability, even for economic instability. So it creates differences or imbalance of economy or morally. So this is not important for a state as a whole, even for individuals. So giving individual right is not important or advantageous than the common one. So this is the argument and what you call Marxist theory. So see in detail by yourself. The other point in this session is land significance. Just land is, as you know, land is a basic important natural resource, and it is a base or a ground for every activity. Without land or without earth, we cannot invest, do, or facilitate anything. So land is very important for every discipline, for every market, for every person, for even for non-living things. This is known. So it is very, very important. Even from other natural resources, land is very important to every activity. The other is scope of right to land. How can we determining our right on land resources. So to answer this question, everything above and below the earth or the surface is included under the right of land. So if there is air above the land and if there is soil or other natural resources related with the land below the surface are included in the earth and what you call in the land rights. So we can handle or hold a right above and below the surface. So the extent of the land rights includes the surface by itself and above the surface and below the surface. So its scope is determined based on this. The other important is forms of ownership. To determine the rights of land rights, there are different ownership types, and when we see the forms of ownership of land, there are 4 types of ownership. The first is private, second communal, state, joint, and common. When we start the first one, private ownership. This type of ownership of land rights is directly gives the ownership right of the land to private individuals. Private persons or individuals can use, enjoy, and dispose absolutely their land rights. So individual persons has a full and absolute right of ownership on the land. This is what does mean private ownership. Second is communal ownership. Communal ownership is a type of ownership and gives ownership right for a specific or certain community. Just like, for example, for grazing lands or irrigation lands. There is a specific or certain land resource and a specific already determined land resource, maybe for grazing or irrigation for other similar purposes, and it gives for a certain specific society, even for lands that are attached with water bodies. So this is a type of ownership type and gives for a certain village or a certain community to use ownership right over the land resource. The third is state or public ownership type. This is also, unlike the first and the second type of ownership, the ownership absolute right of ownership is given to the state or the government. So in this type of ownership, individuals or certain village or some organizations haven't any ownership of land rights on the land resource. So the government has a full and absolute control on the ownership right of the land. So on the hands of the land, the hands of the government has full ownership right. The fourth one is joint ownership. When we see the scope of joint ownership gives ownership right of land for 2 or more persons, and they agree to use this type of ownership jointly. So in this type of ownership, the persons have 2 or more persons, and based on their agreement, they use jointly. Just like, for example, if there is commonly used corridor, just like condominium, parking, just like other types of lands, they are own the ownership right, and they use commonly or jointly, but they cannot divide the right individually, undivided right. So this is what does mean joint ownership mean. The other is common ownership right. When we see common ownership right, this is also another ownership, and this ownership type emanates from the nature of the right of the land resource. It may be, for example, married persons, husband and wife can hold or own rural or urban lands commonly. So they have a common ownership right of land. Or it may be just if there is a succession, which there is a land succession, there are so many successors, so they can commonly use the ownership or hold the ownership right of the land. But if they need to divide their ownership right, they can divide based on their share. Their share may be equal or different. So in the first joint ownership, the right will not be divided even if they need. But in the common ownership type, they can use commonly, but their share is very clear, and if they need to divide or partition their share, they can. So this is the difference between the joint and the common ownership. So this is the main point between these two types of ownership of the difference. The other important point in this session is the scope of land law. As I have said before, the scope of land law is specifically saying land law is a law which regulates the acquisition, the enjoyment, the transfer, disposal, administration, management, and also the dispute resolution mechanism in relation to land. So land law specifically determines on regulating the issues which I have stated before. So its scope is limited on issues related specifically with land matters. The other is, and the final point in this session is object of land law. What is the basic object or subject matter of land law? The basic object or subject matter of land law is, it is real property, or what you call real estate. Or when we say real property or real estate, it is land and buildings or other affixed or constructed things which are highly attached with the land. So the object of land law is land and other attached, or what you call it, maybe building or fences or other similar real properties. So these are the main points we have discussed in this session. Thank you.